Good morning, my name is Alex Lawson and I appear on behalf of the claimant in this matter. The date of this hearing, for the purposes of this assessment, is the 1st of March 2017. The dispute arises from contract serial number STC 689-11080, which was signed on the 15th of December 2015 between the respondent, Massive Resorts Limited, represented here by my learned friend, and Nightingale Limited, the claimant represented by myself. Nightingale are seeking $3 million, which remains outstanding as part of the contract price plus interest, and arbitration was initiated in this matter on the 1st of October 2016. The arbitral seat remains England and Wales as per the contract signed and referred to above. The uncitral rules apply despite, I would submit, the typo which appears in the contract. There is a W transposed in there. On the basis of the intention of the parties and their conduct so far, it is clear that the uncitral rules are to be applied. The purpose of this hearing today is to deal with procedural steps relating to a jurisdictional and admissibility matter, those two which have arisen and been brought to the tribunal's attention by the respondent. It is likely that the tribunal will hear submissions from the respondent on the basis of Article 4.2 of the uncitral revised rules, inclusive of a plea that the tribunal lacks jurisdiction. A statement of defence was submitted in this matter on the 21st of January 2017. Counsel for the claimant has not had sight of this statement of defence and is not aware of whether it contained notice of the jurisdictional challenge. Counsel will deal with the matter as though it did, however. The respondent contends that the court does not have jurisdiction on the basis that, on the 1st of February, a claim was lodged by the respondent in the English county courts requesting that the contract referred to above be declared null and void. On the 11th of February 2017, the county court made an order recommending that the tribunal refrain from hearing the matter until the county court has made determination of the respondent's claim. Secondly, and this is as regards the admissibility of the claim, that it is contended by the respondent that as of the 23rd of February, the respondent has requested that the matter be submitted to mediation. The claimant in this matter has not responded beyond, it appears, acknowledging receipt. Dealing with the first point on jurisdiction, Article 23 of the uncitral rules allows for the severability of the arbitration clause and gives the tribunal the power to rule upon its own jurisdiction. It is unlikely that the respondent seeks to overturn this well-respected principle of competence, and it is beneficial to remind ourselves of the text of Article 23 where it is relevant. 23.1, the arbitral tribunal shall have the power to rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. For that purpose, an arbitration clause that forms part of the contract shall be treated as an agreement independent of the other terms of the contract. A decision by the arbitral tribunal that the contract is null shall not automatically create an invalidity of the arbitration clause. Therefore, the clause shall survive any declaration of invalidity, and it is entirely within the court's own powers and competence to rule upon the contract and its own jurisdiction. 23.2. A plea that the arbitral tribunal does not have jurisdiction shall be raised no later than in the statement of defence, or with respect to a counterclaim or a claim for the purpose of a set-off in the reply to the counterclaim or to the claim for the purpose of set-off. A party is not precluded from raising such a plea by the fact that it is appointed or participated in the appointment of an arbitrator. A plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. The arbitral tribunal may, in either case, admit a later plea if it considers the delay justified. It is assumed, in the matter at hand, that this process was carried out correctly. As previously mentioned, counsel has not had sight of the statement of defence. It is extremely helpful, however, to consider 23.2 in conjunction with 23.3, which I would suggest will form one of the procedural steps we may seek to deal with today, in that the arbitral tribunal may rule upon a plea referred to in paragraph 2 either as a preliminary question, and I would suggest it would be, or submit respectfully to the court, it would be wise to do so at this stage as a preliminary question, but of course it may also rule upon it in an award on the merits. The arbitral tribunal may continue the arbitral proceedings and make an award notwithstanding any pending challenge to its jurisdiction before the court. Therefore, on this basis, I would submit, if the tribunal is with me on this point, that proceedings may continue. The case in the county court is currently pending, and the order made was only a recommendation. The parties agreed to arbitrate, not to litigate the dispute. The tribunal may rule upon its own jurisdiction, as previously stated, and need not stay proceedings while the matter is under consideration as per 23.3. If it is felt necessary, this can later be reviewed by a competent national court. There is no contention by the respondent that the arbitration agreement itself, whilst there is a contention that the contract may not be valid, there does not appear to be a contention by the respondent that the arbitration agreement is invalid. Procedurally, the tribunal, as per Article 23, may hear this application now. I would submit that is the best course. I would also draw the tribunal's attention, just to further reinforce this point, to the Arbitration Act 1996, sections 30 to 32. It appears that no section 32 application has been made at this stage by the respondent, and whilst it is not the purpose of this hearing to comment upon the merits of the claim either in the court or at this tribunal, as regards the court hearing, it is worth remembering that Patel and Mirza, the Supreme Court case last year, did very little to clarify this area, and indeed, in any consideration of costs, it is unlikely that the court action will save any money. The claim is therefore to be decided upon its merits, I would suggest, and at this early stage. 2. As regards the admissibility point, this relates to a mediation clause in the contract which reads, in addition, and this follows after discussion of the procedure for arbitration, in addition, the parties agree to undertake mediation for 45 days at the request of either party. Such request for mediation can be made at any time. As previously stated, a request was made on, if I can recall correctly, the 23rd of February, given that it is now for the purposes of this hearing, the 1st of March, that was a little over a week ago. We are therefore not too far down the line procedurally. While the request has been made and not responded to, only a week has passed. The contract states that such requests can be made at any time. It does not state the time frame for response. It is suggested, however, that this is not a jurisdictional issue or an admissibility issue which would halt proceedings. Mediation requires the voluntary cooperation of the parties, and it appears the relationship is broken down. There is no mention of any adverse effect on either party for failing to mediate in the contract, and while the law of England Wales holds that there may be cost consequences in litigation for failure to mediate, this does not appear to be the case here in the present arbitration. While the arbitration clause itself is severable, I would suggest that the arbitration part of that section of the contract could itself be severed. The mediation clause for the purposes of the tribunal is not necessarily required to be severable. It is also instructive to consider, while not binding, of course, upon the tribunal, that, and I quote from the Court of Appeal, the court should be slow to criticise a party's behaviour where decisions such as when to mediate are matters of tactical importance where different views may be legitimately held. That coming from Car Giant Limited and another against London Borough of Hammersmith, 2017. Secondly, let's look at the clause, what I will term the arbitration and mediation clause. It is prima facie a multi-tiered clause. However, on closer reading, the clause does not require that mediation be engaged in before arbitration. It doesn't set any precondition on this. Indeed, the request to mediate was made shortly before the arbitration hearing today and after appointment of arbitrators had taken place. In any event, it is for the tribunal to decide if such a clause imposes an obligation, I would suggest it does not, and whether such an obligation should be or has been satisfied. It does not need to be in this case. Where a clause is only optional, as is the case here, I would suggest the next procedural step would be for the tribunal to consider, and in my submission, dismiss the challenge. It is very much the claimant's position that despite efforts to avoid arbitration via litigation mediation made by the respondent, the matter should be allowed to proceed with consideration given to these 2 points at this preliminary stage. Much obliged, boss.